Well, up next to be vetted is the Minister-Designate for Attorney General and Minister for Justice, Godfred Yeboah Dame. He used to be a deputy. Now he's going to be occupying the substantive position. We'll take you back now to Parliament.
My name is Godfred Yeboah Dame. I was born on 5th June 1979. I hail from Wenchi, the Brown region. I had my primary education at Cape Coast at Versam Memorial Preparatory School. I had only 1 year of my primary education at Commander College Party School. I proceeded to Adisade College to pursue my ordinary level and advanced level certificates. I completed the O-level in 94, A-level in 96, and I proceeded to the University of Ghana to pursue my Bachelor of Laws degree from 1998 to 2001. But before then, I had done my national service at the KEA district. After the national service, there was 1 year of strike, and for that matter, I had to engage in people teaching at a village called Brassi, also in the KEA district. So after 2001, I went to Ghana Law School, October 2001, completed in 2003 with a professional law certificate. Mr. Chairman, I pursued my national service in this honorable house, completed it in May or June 2004. I did my pupillage at Ekufuado Pempenko concurrently from October 2003 to 2004 June. I continued with my professional law practice at Ekufuado Pempenko. Indeed, I was there apart from 2006, where I had to pursue a course at Oxford University programming comparative media law and policy. I returned to pursue my professional, to carry on with my law practice at Ekufuado Pempenko. I was engaged in private law practice until March 2017, when I was nominated by 2017, I was nominated by the President as Deputy Attorney General and Deputy Minister for Justice. I was approved by this Honorable House, and I was sworn into office on 12th April 2017, and I stayed in that office until 6 January 2021. I was, by the grace of God, nominated again by the President, this time for the office for which I'm being vetted this morning. I'm a Christian. I worship regularly at the Untitled Church. I'm married to Dr. Jocelyn Asimen Dami. We have 2 children. Thank you very much.
Honourable members, you may now ask.
Yes. Thank you very much, Mr. Chairman. I'd like to congratulate my good friend, Honourable Godfred Dame, on his appointment. I take note of the fact that by virtue of the date of birth, you're likely to be one of the youngest Attorney General, if not the youngest. I think it's a significant, occurrence that one must take into cognizance, having regard to the fact that the legal profession, is one that deals with a lot of experience and age. But minded by Article 79 of the 1992 Constitution, I want to premise all my questions, with this in mind, which states, Mr. Chairman, with your indulgence, I will read. The President may, in consultation with the Minister of State and with the prior approval of Parliament, appoint one or more deputy ministers to assist the minister in the performance of his function. My emphasis is on the assist. Now, that notwithstanding, I would like to find out a few things about you to the extent that you were involved to assist. Then you can answer these questions for me or for the committee. The former special prosecutor, in his report on the Ejapa transaction, made reference to the mandate agreement, and he raised a few issues, one of which is the lack of capacity of the former Deputy Minister for Finance to execute the agreement And two, that the agreement should be one of the agreements that comes under Article 1815, that also requires prior parliamentary approval, as well as the approval of the Public Procurement Authority. Now, do you share that view of the special prosecutor?
Chairman, thank you very much for the question. Indeed, the special prosecutor,
the former special
prosecutor, but indeed by mentioning special prosecutor, I was referring to the office of the person. So, carried out what he termed risk analysis of the risk of corruption and anti-corruption assessment of the processes leading up to the request for approval and approval of the transaction agreements and tax exemptions granted thereunder in relation to the gold royalties monetization transaction and the Minerals Income Investment Fund Act 2018 at 978. And other related matters there too. The Chairman, I quoted the full title of the work because the context in which the exercise was carried out must be made clear. Indeed, the special prosecutor indicated that he was acting in line with what he described as risk assessment. And it is worthy to indicate that in Act 959, the Special Office of the Special Prosecutor Act, explicitly, the exercise described as risk analysis or assessment of corruption risk is not indicated. The only clue a person may have as to the set of functions that the Office of Special Prosecutor has been given by Act 959, and a clue whether it includes risk analysis is with regards to Section 2 of the Act. And in Section 2 of the Act, with permission of the Chairman, if I may quote, said the object of the office is to A, investigate and prosecute specific cases of alleged or suspected corruption and corruption-related offences. B, recover the process of corruption and corruption-related offences. And C, take steps to prevent corruption. Indeed, it is pertinent to indicate that it is this C that the Office of the Special Prosecutor indicated to the public that he was proceeding under. So he considered the conduct of corruption risk assessment as part of the preventive mechanisms that he could deploy to curb corruption. Even though it becomes a matter of interpretation, whether indeed taking steps to prevent corruption can include the conduct of such an exercise. I think that I will be liberal enough to say, fair enough, it could perhaps have come under this provision, even though I've indicated that yes, it's debatable and it's questionable. But the fundamental problem that one may have is that even though Mr. Amidu indicated that he was conducting risk assessment, which of course will entail examination of a specific transaction and its future hazards that transaction may represent. Upon the presentation of that report, of course, he did not owe a duty at all to present the report to the President. I did not see anywhere in Act 959 that mandates the Special Prosecutor to present a copy of the report to the President. But that's the step he took. He presented a copy of the report to the President. And in doing so, he himself spelled out the rationale for doing so. The rationale for presenting a copy of the report was indicated by the Special Prosecutor in his letter to the President, dated 16th October 2020, as informed by the fact that whatever he did was supposed to guide future actions.
Chairman, just sorry.
Minister nominee, just hold your breath there. I'm indulging the chairman. You are saying that the special prosecutor was not required to present the report to whom?
To the president.
To the president.
To the president.
It was not required.
It's not required.
Are you aware whether there was a referral from the president to the office of the special prosecutor? You have any indication?
I'm not aware.
You are not aware?
He indicated in his letter that he was carrying out the exercise of his mandate under Section 2, Paragraph C of Act 959. So that's the report.
But you are aware that the special prosecutor, if you read the act that you referred to, was independent on any matter.
Yes.
He could institute an investigation for the purposes of the general good of the country. Do you agree with that?
I agree, and that's not the doubt.
Okay, you can continue. Thank you.
Mr. Chairman, and it's actually in line with that I say that he was not obliged to present a corporate report to the president. But he indicated in the report that he presented to the president that he was doing so because the exercise that he was carrying out was only supposed to guide future executive actions of government. And for that matter, he did so. Now, the little fundamental issue I have is that if a report of this nature is prepared and is supposed to guide future executive actions of government, and same is presented to the president, and then upon the perusal of the report, there's no indication of a grant of a hearing to certain public officers whose conduct.
Honorable Attorney General nominee, was any of the people mentioned in the report contacted? Was any of the people mentioned in the report contacted or actors in the processes contacted according to the report?
Sure. So the Minister of Finance was indicated. There was also reference to the Minister for Finance in the report. The point I'm making is that even though those persons were not given a hearing from the report, and the special prosecutor has indicated that that report was supposed to guide future executive actions of the president. When the report was given to the president, of course, in accordance with the requirements of Article 296, which enjoins a public officer to act reasonably, requested the officer in question, that is the special prosecutor, to grant the affected public officers a hearing. Then, surprisingly, the special prosecutor construed that request of a hearing to be an interference in his work, and so he resigned. That's my first point. Now, to address my
Chairman, so he resigned. Are you attributing his resignation to that? Because there is a formal correspondence on his resignation.
Yes, there is.
Are you attributing his resignation of the special prosecutor, Martin Alamis to what? I just want to hear you for the record.
Mr. Chairman,
when you say then he resigns, what are you implying? Right.
Mr. Chairman, he indicated clearly in the letter of resignation that he was resigning on account of the request of the president to, as it were, contact the Minister of Finance to be given a hearing. So it is the letter dated 16 November 2020, by which the special prosecutor resigned.
And it's further, Chairman, your indulgence, it's further your submission that the special prosecutor did not hear persons affected by his report. Is that your submission to this House?
Mr. Chairman, that is so, apart from the request for documents that he had made of the Minister of Finance. So that is, I think, the unfortunate circumstance that characterized the work of the special prosecutor. Now, to specifically address the question asked by the honourable member, whether I agree with the finding of the special prosecutor that the Deputy Minister for Finance, then, such as Yeboah, they don't have capacity to execute the mandate agreement. I respectfully disagree. I disagree because the capacity to execute a financial agreement has been indicated in the Public Financial Management Act. In there, we find that, Mr. Chairman, the capacity is given to the Minister for Finance or any person that the Minister for Finance may authorize. And in this regard, I may refer to section 5. I'm sorry. That's why may I just to be right. That's why section 5 of the Public Financial Management Act indicates clearly that a person with the capacity to sign agreements under the Act rests in the Minister for Finance, or any person not below the rank of a director that the Minister will authorize. In the light of this, it becomes quite clear that the Deputy Minister for Finance, if he was authorized by the Minister for Finance, had full capacity to execute.
Chairman, just another, we are listening to Kinley.
Honorable committee member, you are not permitted to do that.
We appreciate your reference. You are entitled to your view. Capacity of a minister, yes, and capacity of a deputy minister, and capacity of persons identified in the Public Financial Management Act, as you have referred to, so continue. I'm putting it in context.
Right.
So, within the meaning of Article 78 and 79 of the 1992 Constitution, the capacity of a minister, yes, the capacity of a deputy minister, and those that you have just referred to, but continue.
Right. That's one. I'm very grateful for the allusion to Section 79, Article 79, Clause 1 of the Constitution, because indeed that clearly will buttress the point that the Deputy Minister for Finance, if he had been authorized by the Minister for Finance to undertake a special function, then a Deputy Minister for Finance was duly authorized, because the functions of a Deputy Minister, as set out in Article 79, Clause 1, is to assist a minister in the performance of his functions. That is not in doubt. Then Section 5, Subsection 1, Paragraph C of the Public Financial Management Act, Act 921, stipulates as follows. Pursuant to Section 4, the minister may, C, acting on the advice of the Attorney General and subject to the approval of Parliament, enter into and execute an agreement on behalf of the government in relation to matters of a financial nature. So primarily, the capacity to execute any agreement on behalf of the government of Ghana in relation to matters of financial nature rests in the Minister for Finance. Now, the provision goes ahead to stipulate in subsection 2 that the minister may delegate any of the responsibilities under subsection 1 to the chief director or to a senior public officer not below the rank of a director within the ministry, but shall not relieve the ultimate responsibility for performance the delegated responsibility. That Chairman, it is not in doubt that a deputy minister is definitely above the rank of a director. And therefore, if a function under Section 5, which is to execute any agreement of financial nature, has been so delegated, I think that delegation is proper. Further, in terms of execution of contracts, financial contracts, state contracts, there is also what we call the State Property and Contracts Act. The State Property and Contracts Act also authorizes the minister in respect of a special subject matter or a person that the minister may delegate that function to.
Just for my record, quote the act number and then the year. Execution of contracts, what you are referring to for our purposes, Chairman.
Chairman, the State Property and Contract Act of 19. Chairman, is CA6, 1960. CA6 is an old law. And stipulates in Section 2 as follows.
Just read the rendition full for me. CA6.
State Property,
yes,
and Contract Act.
Okay, thank you.
1960, CA6. It's an old law. So the point that is being made is that even before the enactment of Act 921, authorization to execute government contracts is set out in law. And that authorization in Section 20 of CA6 goes as follows. It says the minister responsible for a subject or department any other person authorized by the minister may execute a contract for and on behalf of the Republic on a matter falling within the minister's portfolio. So the operative words here are the minister responsible for a subject or a department or any other person.
I think you've spoken to this matter.
So I've viewed that finding with all respect. It's not entirely accurate. That's my humble opinion. And indeed, I may also add that the special prosecutor, in the work that he did, essentially was expressing an opinion on a contract, part of which has been approved by this Honorable House.
Thank you. So if you are expressing an opinion, what are you doing now? What are you doing now?
What am I doing now?
Yes.
That's why I'm expressing an opinion on his opinion.
Thank you.
Based on the question that has been asked by the Honorable Member.
Yes.
Your mic.
Thank you very much, Mr. Chairman. Now, some have held the view that the position taken by the former Attorney General, your immediate past boss, is that of one that is against the transaction. Are you able to confirm whether that is the position?
The opinion is one that's what? Against the transaction. Mr. Chairman, I think that may be, respectfully, a little bit of an erroneous view to take. I say so because the Attorney General's opinion on the matter, as far as I'm concerned, is a final one given on the matter. Now, there were a series of transactions, and I think that must also place on record that in terms of actual work on the Japan transaction, I was not part of it. I was not part of it because of the schedule of work at the Attorney General's Department. Work is assigned by the minister, as the Honorable Minority Leader indicated. The Deputy Minister says the minister and work is assigned and that kind of thing. But even though I was not part of it, I've had the opportunity of examining the series of Attorney General's opinions delivered on the transaction. And I would say that the first one that came to my attention was the one dated 1st April 2019. And Mr. Chairman, you will note that the first opinion dated 1st April 2019 was actually...
For the record, opinion by who?
By the Attorney General.
Name for our record.
Attorney General, my boss, Madam Gloria Kufo.
Proceed, sir. Chairman.
And indeed, that opinion constituted an examination of a draft agreement. And in the regular course of a lawyer's work, whether in private practice or public service, if your client has a draft agreement and the draft agreement is presented to you for review, the lawyer will conduct a preliminary assessment of the agreement and deliver an initial opinion. After, the lawyer may recommend to the client to undertake certain changes or amendments in relation to certain draft provisions of the agreement. And that's exactly what the Attorney General did in this case. The Attorney General delivered her first opinion on 1st April 2019, and as I indicated, it constituted preliminary observations and recommendations. And the first one contains certain general comments. Part of it will indicate that she recommended that there be insertion of this provision or that provision, and that even certain provisions would infringe on the exchange laws of the country and have to be taken out.
Chairman, may I request of you that if the nominee wants to quote verbatim from it, we would appreciate it. Or we have an assurance that he will tender this in evidence to our committee for our purposes. But if he can emphasize the areas to which, when you say general and specific, we are not holding it to follow you. So for our purposes, we need to be guided. And then if you just give the date of 1st April 2019, if you have the date of the second and third opinion, just give it to us. And then I take Chairman's lead that you would make those documents available to us. And then mine is, you share the view that Gloria Akufu, respected Attorney General as she then was, did this within her mandate under Article 88 of the Constitution. Do you share the view?
Fully. I fully share the view, and I also will add further that the first April 2019 letter by the learned Attorney General did not constitute a final opinion on the matter. And Mr. Chairman, if I may quote from the first paragraph of the letter, it says, we have reviewed, the first letter is referred to a letter dated so and so. In the second paragraph, we have reviewed the draft agreement as well as the relevant law and make the following observations and recommendations. So whatever followed constituted recommendations based upon her initial review. Mr. Chairman, I'm prepared to tender that document if I'm requested to do so. Then there was a reply from the Minister of Finance. The Attorney General looked at the Minister of Finance's reply and wrote another letter dated 28 May 2020. Mr. Chairman, the first paragraph indicates...
Can I just clarify, letter or opinion? The first you said opinion, 1st April 2019. Yes. This one, is it a letter or opinion? What is your description of
it? It was further observations contained in a letter.
Okay, thank you.
So the Attorney General wrote another letter, further bringing to that Minister for Finance's attention more observations that she had made upon the perusal.
I'm sorry, the date, the further observations.
And it was dated 28 May 2020. 28 May 2020. 2020. Because the reply from Minister of Finance came on 18th March 2020. The first letter by the Attorney General compelled the Minister of Finance to undertake a review of the transaction, and I believe that it took quite some time. So they delivered their reply about 6 or 7 months later on, and that was dated 18th March 2020, to which the Attorney General by this letter, 28th May 2020, replied. And it's also available. And Mr. Chairman would note from the comment that it again did not constitute a definitive opinion on the matter at all, because it contained only further observations and requests for the alteration of certain provisions of the transaction. And the Attorney General indicated a satisfaction of certain things that had been explained to her, pursuant to the letter that she had earlier on written. So, the Chairman, that is also there. The Minister of Finance, a month later on, replied through another letter dated 22nd June 2020 and brought to the Attorney General's attention further amendments to the transaction documents. The Chairman, that can also be tendered. And the Attorney General conducted further review of the draft agreements that had been made again, and by another letter dated 22nd July 2020, also furnished further comments which will aid a revision of the transaction. So it's also signed by our boss, Madame Gloria Kufu, dated, so that can all be tendered. The Chairman, there was another letter written by the Attorney General dated 5th August 2020. And that, as far as I know, was the last correspondence from the Attorney General to the Minister of Finance before the President's directive that the transaction be looked at again. So, Mr. Chairman, in terms of the observation by a person that the Attorney General was opposed to the transaction, I believe that that is egregiously wrong. It's very wrong and must be corrected. Indeed, all I have before me are a series of letters containing observations written by the Attorney General, most of which were incorporated into the revised drafts that were undertaken by the Minister of Finance.
Just a little clarity. So, by your submission so far that I have followed religiously, are you seeking to disagree with Attorney General Gloria Akufu, or you are leaving a thesis that she was not opposed to the transaction? What are you seeking, just for purpose of clarity?
Mr. Chairman, indeed, I stand with all respect by everything Madame Gloria Akufu did in respect of this transaction, and I'm not opposed at all to anything she did. Second, I'm only indicating for the record, that the Attorney General, Madam Godfred, at that time, was never opposed to a transaction. And that is clearly discernible from a perusal of all the documents before me. And her final letter, actually, was an indication. I think it's very important to note that the final letter written by the Attorney General, which I indicated, 5th August 2020, comments as follows. The opening paragraph referred to your various advice dated. So she indicated our various advice dated 1st April 2019, 28th May 2020, 22nd July 2020, and the transaction advices comments dated 12 June 2020 and 22nd July 2020, respectively, on the Kingdom investment arrangement for proposed monetization of Ghana's mineral royalties. And the second paragraph says, we note that the TA, that's the transaction advisor, has incorporated some of our previous comments into the agreement, whereas he has raised issues with others for our reaction. We have studied TA's responses and comments as follows. And then she made further observations and comments. And those observations, as far as I'm concerned, usually were cast, conditionally, that if this can be done, then this will follow. I believe that when the committee looks at it, the committee will be better appreciative of the position I've taken.
Yes. Are you done? Your mic, please. Nominee, your mic.
Thank you very much, Mr. Chairman. Now, beyond the furore and then indignation that greeted the Ejapa deal, and all that you know and all that you have told the committee, do you see any vitiating factor, anything that will vitiate this contract, or you think it's perfectly impeccable, in the language of Right Honorable Peter Aladede? Perfectly impeccable.
Very much so. The Right Honorable Aladede described it as perfectly impeccable. I'm not sure.
He's saying the language of means he's referring to something else he had said earlier.
Okay, so words that he used to, he very much loved. Mr. Chairman, I, with all respect, cannot see any vitiating factor with regards to the transaction. I think I may place on record that the special prosecutor...
Chairman, just for the record, the Honorable Tampule used the word vitiating to a contract. In your answer, you are saying vitiating to a transaction. Words matter for our purposes. What word do you want to use for purpose of vitiation?
Mr. Chairman, there may be clarity with regards to which of the contracts, because there are a number of transaction documents. Is it the mandate agreement? Is it the mineral royalty agreement?
On the records, I'm referring to the mandate agreement. I'm referring to the mandate agreement, just for the records.
I'm very grateful. Mr. Chairman, in terms of the mandate agreement, there are three major factors that were cited by the former special prosecutor as, if one may describe it, as constituting vitiating factors. Now, the first one is the lack of capacity of the Deputy Minister for Finance to execute the transaction. That I have addressed, and I would not bore the committee with further comments on. The second observation was with regards to the alleged unconstitutionality of the mandate agreement. And Mr. Matiamidu contended that to the extent that the mandate agreement was not presented to this Honorable House for agreement, it was null and void. Because his understanding was that the mandate agreement constituted a business or economic transaction because it was with a foreign entity. And therefore, by operation of Article 181, Clause 5, it should have received parliamentary approval. Mr. Chairman, I disagree because Article 181, Clause 5 has been interpreted by the Supreme Court on numerous occasions. Apart from the initial one, Ferro-Atlantic, Attorney General versus Ferro-Atlantic matter, there has also been Attorney General versus Bakan Energy, reported in, I think, 2012, Volume 2, Supreme Court of Ghana report, at page 998. And I think that it's very important to also place on record that Mr. Martin Amidu was the Attorney General then, and he prosecuted the case on behalf of the government of Ghana. And in that matter, with all respect, what constitutes an international business transaction was examined by the Supreme Court. And the Supreme Court came to the conclusion, the holding, that it is definitely impracticable to have every international business or economic transaction come before this honorable House.
Chairman, I'm enjoying the submission of the nominee. You referred to the Faro-Atlantic case. You referred to the Balkan case.
Yes.
I'm also aware of Martin Amidu versus Attorney General.
Yes.
Can you quote exact which one you are relying on for our record, since it's a Supreme Court ruling? Thank you.
Very well. So the one that I was just referring to is Attorney General versus Balkan Energy Ghana Limited and another, reported in 2012, Volume 2, Supreme Court Ghana report, at page 998. And indeed, if I may quote for the committee, just briefly what the Supreme Court stated. At page 1032, the court indicated that for clearly, it would be impractical for Parliament to scrutinize and approve every single business transaction with international ramifications entered into by the executive. In our view, to give effect to the Framers' purpose, there is need to imply into Article 181 Clause 5 an understanding that only major international business or economic transactions are to be subject to its provisions. Then the court also continued at page 1033.
Chairman, so I'm following through. Only major.
Only major. That's the first
So,
point.
by your assumption, was Ajapa major or minor? Relating it to what you just quoted, was the Ajapa transaction, mandate agreement, major?
The mineral royalties agreement itself was a major transaction. And I'm saying so because the Supreme Court in this same case construed a major agreement to be the substantive or primary agreement.
Chairman, my follow-up is specific. Was the Ajapa royalties transaction a major transaction in your view or not?
There's nothing like a transaction that has been signed by the government of Ghana. There were agreements signed by the government of Ghana. So there is one.
So if a transaction is not signed, Chairman, how can it be vitiated?
That is why your earlier question was very important. You sought clarity of the honourable member, which of the agreements he was referring to. The honourable member alluded specifically to the mandate agreement. And I'm saying with all respect that the mandate agreement in the circumstances was not a major agreement. It was not a major agreement because it was not the primary or substantive agreement itself. And the Supreme Court...
So the mandate agreement on Ajapa, yes, in your view, was not a major international economic transaction?
Yes.
Thank you. That's all I wanted to say.
But I must explain why it was not a major agreement. And I'm saying that in Balkan Energy, the Supreme Court construed a major agreement to be the primary agreement itself. So all other transactions or agreements that flowed from the primary agreement or could be construed as subsidiary need not be submitted to this honourable House for approval. Indeed, Balkan Energy, the reason why the court declared the transaction as unlawful or unconstitutional was that the agreement in question was a major one. It was an emergency power purchase agreement. So the power purchase agreement itself was a major agreement. But then other agreements like, say, an agreement for the furnishing of a letter of credit and such do not have to come before this honourable court. Indeed, the mandate agreement was an agreement for the appointment of a transaction advisor. And all the records of, with all respect, this country, even before 2012, has pointed to the fact that whenever the Minister of Finance is entering into a transaction agreement, it does not, an agreement, for the appointment of a transaction advisor, it does not submit it to this honourable House for approval, because it is not a major agreement. And I may, if the committee will permit me, quote from page 1033. It said that, on the other hand, the framers could not have intended the obvious and foreseeable paralysis from overloading Parliament that would ensue from interpreting a provision as covering every single business or economic transaction with an international dimension. The implication into Article 181 Clause 5 of the attributes of being major before a transaction enters into its ambit would thus seem to be necessary and reasonable and within the spirit of the Constitution. Then it says the defendant's hypotheticals are only a sample of many other transactions which could literally be brought under the umbrella of an international business or commercial transaction, but which would not be so construed. So it goes ahead. Indeed, the example that was quoted by the defendants in the matter was, what if the government of Ghana, for instance, is buying air tickets for the travel of,
Chairman, just one more.
Of people? Yes, of course.
You want to refer to which ratio, whose ratio decidendi are you referring to?
That's for the purpose. Right. The judgment of Dr. Justice.
Justice, the full title.
His Lordship Justice Dr. Dateba JSC.
Dateba?
Yes, please.
JSC.
Yes, please.
Okay, thank you. Just for the record, we needed to know who you were quoting as your authority. Thank you.
So, if one were to apply the holding in this case to the transaction in question, I will submit finally that to the extent that Parliament had considered and approved the substantive agreement itself, the primary agreement being the mineral royalties agreement, other subsidiary agreements like an agreement for the appointment of a transaction advisor ought not to have come before the Honorable House for approval.
Very well.
Mr. Chair.
Yes.
Honorable nominee, is it your case that...
Are you doing a follow-up on any
yes,
matter?
please.
Otherwise, I should go to...
Just a follow-up on the point he made. Is it your case that the transaction itself did not have government as a party, and that it is by entities that are independently registered to operate with that capacity? Is that your case by way of your response to the question?
Gentlemen, that is not my point at all. The point I made was just simple. The transaction was between the government of Ghana and certain entities. Indeed, the transaction that is being impugned here is a mandate agreement executed between the Minister of Finance on behalf of the government of Ghana, necessarily, and Imara Company, South Africa, as well as Data Bank of South Africa. And the question here was whether the presence of the Imara Limited, which is a South African company, made it an international business a commercial transaction for the purpose of Article 181, Clause 5. And my contention is that, as the Supreme Court has held in the Balkan case, it's only major agreements that ought to come before this Honourable House. A major agreement necessarily should be in reference to the primary agreement itself. The primary agreement had come before this Honourable House, and therefore such minor agreements which would facilitate the execution of the primary agreement ought not to have come before this Honourable House.
Honourable Agaga.
Now, Mr. Dami, you have sought to distinguish between the Attorney General versus Faro Atlantic Company Limited and the Balkan case. And it is your view that the mandate agreement did not constitute a major agreement to have warranted parliamentary approval. Now, let me ask you this question. What was the fee that Imara, under the agreement, was supposed to be entitled to?
Mr. Chairman, I think it was $15,000 per annum. I stand for correction, but I think it was $15,000 per month. $15,000 per month.
Now, beyond that, what was supposed to be the success fee, that is, following the consummation of the deal in terms of the services Imara was supposed to render?
Mr. Chairman, this percentage was also indicated in the agreement. I think it was, Mr. Chairman, if I may respectfully be specific by referring to the agreement itself. Chairman, but per my crude reckoning, I think an amount between about 3 and 4 million, if the transaction eventually became successful, would have been paid. But that's just my crude analysis.
We want what is in the agreement. Your reckoning may not be correct, and our record must reflect.
So we can make progress. Yes, Mr. Nominee, the figure in question is actually $4 million.
4 million.
Yes.
So, Mr. Chairman, my crude mathematics.
Yes, can you? Yeah.
My crude mathematics was quite right. I was looking for the agreement itself, but if the honourable member has it before you and has.
Now, Mr. Dami, would you still insist that a transaction which involves the payment of $4 million United States dollars to a foreign entity would not qualify for a major business transaction?
Mr. Chairman, with all respect, in terms of the character of the agreement and in terms of the quantum of the sum, they do not qualify as international major agreement, major business or economic transaction. I will explain so because fundamentally, to the extent that it was not the main agreement regarding the transaction, it did not even qualify at all. Secondly, even if it did, on account of it being $4 million, I'm not trying to be, in fact, I did not have $1 million, but I'm just saying that in the scheme of things, it does not qualify for a major business agreement. Because, as was alluded to in the matter, the situation where the government of Ghana buys air tickets for its public officers will be material. It never comes before its honorable house. Indeed, the government of Ghana buys air tickets all the time, I'm sure definitely every year to about $4 million or more. It never comes before its honorable house. So I think that we ought not to look at the quantum as constituting a basis for subject nature. Because the first fundamental requisite, that's not even coming. It's not a major agreement in the sense that it's not the main agreement. It's only a subsidiary agreement or an agreement which facilitates the execution of the main agreement.
But, Mr. Dami, you would agree with me that the agreements in question, all 5 of them, the gold royalties monetization transaction agreements, were intertwined. In other words, they were interwoven in such a manner that to take out one in isolation and place meaning onto it without reference to the others would lead you to error?
No, Mr. Chairman, I respectfully disagree. That is why I did not refer just to the Faro Atlantic case. When the Faro Atlantic case, the question as to whether each international agreement ought to come before the Honorable House was also considered. But just the broad question of whether Article 1815 should be construed to mean international agreements should come before this Honorable Court and this Honorable House. And the court answered in the affirmative. The only time the Supreme Court had opportunity of considering the elements of international business or commercial transactions was in the Bakan energy case. And indeed, with all respect, I'm not the Supreme Court yet. The Supreme Court itself, which is the highest court of the land, held that it will be impractical and it will be one which sounds in absurdity for every economic or business transaction, international business or commercial transaction, to come before this Honorable House. It should be only major agreements. And the major agreement is the agreement itself, from which such small issues as appointment of a financial advisor will flow from.
Mr. Dami, before the appointment of the transaction advisors, under the Public Procurement Authority Act, the bidding process had to be complied with. Nevertheless, now, is it your case that particular procedure captured under the Public Procurement Authority law could also have been glossed over because this transaction was minor in nature and character?
Well, Mr. Chairman, I'm very happy the honourable member, my very good friend, you have a nickname that I will later on tell Mr. Chairman that you were called by when you were linking up about 20 years ago. Now, Mr. Chairman, the Senior Prosecutor indicated also in his report that the mandate agreement was vitiated by the lack of procurement approval. And the reason for so holding was that Data Bank, which was also a signatory to the agreement, was not one of the companies mentioned in the PPA approval to engage with the tendering. And again, with all respect, I will disagree with that finding. I disagree with the finding because the documents I have seen will show that by a letter dated a letter dated 6th October 2017, the Minister of Finance requested from the Public Procurement Authority approval for direct invitation of certain companies to be appointed as a transaction advisor in this matter. By
Chairman, just letter dated 6th October
2017.
2017.
Yes, please.
And the letter is from
Minister of Finance to the Public Procurement Authority.
Addressed to
the Mr. ABJ, Chief Executive Officer, Public Procurement Authority.
All right, thank you. Chairman will request that he also submits that in evidence for our purposes.
Well.
Thank you.
Mr. Chairman, it is headed Request for Approval for Direct Invitation. And it goes, just a very short letter, and talks about the need to appoint a transaction advisor, and therefore they are applying to PPA for approval in that regard. The PPA, by a letter dated 6th November 2017, referred to that letter and requested the Minister of Finance to do two things. It says, one, a list of the shortlisted firms to include their SNATE tax and VAT certificate. And then two, the estimated cost breakdown of the assignment to be undertaken. The Chairman, the Minister of Finance complied, and by...
Chairman, again, you said three things. You've mentioned two. List of shortlisted firms, cost breakdown. The third, you started with three.
That's
it is two and five.
I said two things.
Two things, okay.
Yes.
List of shareholders.
List of shortlisted
firms for
the transaction.
Which transaction?
Technical advisor or transaction advisor? The transaction advisor. Transaction advisor.
For the activity.
Chairman, in the Minister of Finance's letter, they said they were implementing the Minister of Finance.
You want to read the heading in full? The 16th November 2017 letter from the PPA to the Minister of Finance.
Chairman, the PPA was replying to the earlier letter from Minister of Finance.
Yeah, I just want the heading.
Okay. So the heading was by the PPA, the PPA letter?
Yes.
Oh, it said request for approval for direct invitation.
Thank you.
/ technical advisor. And it goes ahead. And, Mr. Chairman, there was a reply to that letter by the Minister of Finance, and it was dated 14th November 2017. In that letter, the Minister of Finance indicated a short list of 8 firms, international firms: JP Morgan, Goldman Sachs, Imara Corporate Finance, Citibank, Morgan Stanley, Barclays Bank, Standard Chartered Bank, and Rothschild and Co. And then indicated at paragraph 3 of the letter that the above listed firms are international firms and are unable to provide the PPA with valid VAT, SNATE, and tax clearance certificates. Because the court, I'm sorry I said the court, the committee will understand that indeed, because they are foreign firms, they cannot have VAT or SNATE forms. The Chairman, by a letter dated 16 November 2017, the Public Procurement Authority granted approval, and this is very important, granted approval under Section 38A of Act 663 to use the restricted tendering method to engage a transaction advisor among the list of selected firms.
Chairman, just the date again, the approval letters date.
16 November 2017, 16th November.
16. Thank you.
November. And the approval was under section 38A.
Of Act 663.
Yes, please.
Thank you.
Mr. Chairman, I consider the section 38 very material because section 38A of the Procurement Act regulates restricted tendering. And if the committee looks further beyond section 38A and looks at section 39, subsection 3, it stipulates that the provisions of Part 5, but not section 47.
Chairman, just clarity. In the approval letter, reference was made to section 38A of Act 663.
Yes. And
what you are referring to, was it referred to or you are referring to it?
Chairman, they go together. They go together.
No, and I'm saying, was it referred to by the PPA in their letter or you are making reference to it?
Chairman, it was not referred to the PPA letter.
Thank you, that's fine.
But it constitutes procedure for restricted tendering.
Thank you.
We want to differentiate between what is in the letter and what is your addition.
Very well. Chairman, what is in the letter, section 38A? Indeed, the provision itself should have been section 38(1)A. There's nothing like section 38A, so it should have been section 38(1)A, as section 38, subsection 1, paragraph 8. It's a general direction for restricted tendering to be engaged in by an entity, a general permission in that regard. Section 39(1) is what sets out the procedure for restricted tendering. So, Mr. Chairman, definitely it cannot be right or justice will not be served by taking account of only section 38(1)A. Because indeed, when an entity is giving approval under section 38(1)A, that entity will have to comply with section 39. And section 39 is what sets out the procedure.
It's appreciated, but just to elucidate further information, do you serve on the PPA?
Mr. Chairman, I do.
And at that material time, you were a member of the PPA?
Mr. Chairman, yes, please.
Thank you. Thank you. That's fine. Thank you.
Mr. Chairman, the point that is made by reference to section 39 is that when approval is given by an entity to conduct a restricted tendering, that approval enjoins the entity in question to adopt all the procedures for a tender. And first, the entity will have to launch its own rules for the tender. So the rules for the tender will then have to be regulated by section 39, and as I indicated, section 39, subsection 3 will say that the provisions of Part 5 of the PPA Act will then apply to the tender. So, the Minister of Finance, upon a study of the documents that I have, then set out to launch its tender. And the tender is governed by rules determined by the entity. The Chairman, the PPA, Public Procurement Authority, does not launch a tender. It doesn't open a tender at all. And it doesn't set rules for a tender. The rules for a tender are usually set by an entity. Mr. Chairman, I have seen a document titled Confidential Report. Mr. Chairman, even though it's confidential, it was from the Minister of Finance, and I'm a public officer. I'm appearing before another public institution, Parliament of Ghana. And therefore, I take the...
Honourable Member, this is a public hearing.
Yes, the public hearing.
If you consider it confidential, please table it. We'll look at it.
Very well. That's why I'll table it, but it's the report of the evaluation. And the report of the evaluation of the tender will show that the Minister of Finance set out rules for the tender. And the tender rules require that any of the firms which have been approved by Minister of the Public Procurement Authority was required to engage in a tender pursuant to collaboration with a local entity. So indeed, a foreign firm which had been listed could only bid or was encouraged to bid after forming a consortium with a local firm. And Mr. Chairman, that requirement or permission to form a consortium with a local firm to bid for a procurement or to participate in a procurement activity is not offensive or alien to the PPA at 663. Mr. Chairman, that is why I take the view that indeed the mere participation of a local firm in the bidding process did not violate at 663. And I would also add that the rule or the requirement for a foreign firm listed among the firms that have been approved by PPA to enter into a collaboration with a local entity was not discriminatory at all. It was not discriminatory because that rule was open to all the firms that engaged in the transaction. So the report that I have before me, which pursuant to the advice of the minority that I will table, will show that in spite of the 8 firms having been invited, only 2 eventually submitted the application. And the 2 firms which submitted the applications both had local firms. So that supports the contention that the requirement for the firm to have a local collaborator, if I may say, so was not discriminatory. And Mr. Chairman, I have not seen any provision of accessibility that is violated.
The question you were asked, I thought you have answered it. So leave it. If you want another question, they will answer it. Otherwise, we will spend the whole day here today. Yes,
I'm very grateful.
Yeah. Now, Mr. Dami, you sought to suggest that the submission of a report by the special prosecutor to the president was not warranted by any law. But you would agree with me that the mandate of the special prosecutor included implementing strategies to prevent. So the preventive mandate of the special prosecutor to the corruption also made it possible for him to conduct the risk assessment of corruption that he did in respect of the gold royalties transaction agreements.
I think 2 points are embedded in the question. The honourable member, if I got him correctly, is indicating that I suggested that the referral of the special prosecutor, referral by the special prosecutor of his report to the president was not warranted. Was that part of it? Yes, that one, without any reservation, I'll contend so, because there's no provision which requires an investigator to submit his report to the president. The CID conducts investigations all the time. The IOCU conducts investigations all the time. And whenever they do, they present their reports, if any at all, to the Attorney General for the Attorney General to prosecute. And in this case, the special prosecutor had prosecutorial powers. And if he has prosecutorial powers, he just proceeds to prosecute. That is one. The second point too is whether the corruption risk assessment did not violate Section 2. Is that your question? Okay.
From your answer, what I could deduce is that you were suggesting that the procedure of submitting a report to the president in itself was wrong in law. Now, but do you know that corruption in itself has so many implications, including security implications for the country, and that the president, as chairman of National Security Council, is entitled to receive such reports from an investigator, such as a special prosecutor? There's nothing wrong with that.
Gentlemen, there's nothing wrong with that. Indeed, he can do as he desires with his report. The point I'm making is that in terms of the law, he is not mandated to present his report to the president. He could have acted on it. He chose to have regard to certain considerations and present it. And I think it is very fair to him to also indicate that he stated the reason for so doing. He stated that the report was supposed to guide future executive actions of government. And that is why I also added that if the report was intended to guide future executive actions of government, and the president acting on this statement requires the public officer affected to present his version of facts on the report, then it cannot be wrong.
Anyway, let me move away from Ejapa and follow-up questions. Yes.
No, remember, even with follow-up, you have more than, I'll give you one more.
Very well, yes. Now, Mr. Dami, I want us to talk about public order here. Public order. Yes. You are the Attorney General-Designate. And so, definitely issues bordering on public order would fall within your province if you're given the nod. Not too long ago, the Greater Accra Regional Police Command went to court and obtained some injunction order. The injunction order was obtained without recourse to service of whatever process they may have filed before the court on the NDC as a political party, even in the face of some decisions of our courts, which clearly states that in matters of the enforcement of public order in respect of the right to demonstrate, ex-party injunction applications are completely prohibited. I'm referring to the famous Occupy Ghana case, which said Dennis Ajay, a Court of Appeal judge, sat as an additional High Court judge and made that famous pronouncement. Now, should you become Attorney General, what would be your attitude towards the enforcement of the right to demonstrate, which is fundamental under our Constitution?
Chairman, I think that Justice Dennis Ajay, even though a Court of Appeal judge, gave that judgment as a High Court judge. So the decision in the Occupy Ghana case was actually a High Court judgment. And it did not matter that the judge who constituted what the lawyers call the quorum, he was a Court of Appeal judge. It still was a High Court decision. Now, it's very relevant because the case you refer to, which is the application for an ex-party order by the police service earlier this year, around 5th January or so, I think, it was, or just before the Christmas, was also a matter before the High Court. And stare decisis, the principle of stare decisis, that is the principle which requires judicial precedent to be observed, is very fundamental to our jurisprudence. And a High Court decision is not binding on another High Court. We all know that. It's actually decisions of other superior courts, Supreme Court and Court of Appeal, which are binding on the High Court. So I would say that fundamentally, one cannot say that merely because the High Court differently constituted in the matter that we refer to, came to a conclusion or granted an application in a manner different from the judgment or the terms of judgment given by Justice Dennis Ajay. The High Court was in violation or the High Court disobeyed the principle of judicial precedent in that case. I think that must be made correct. Because indeed, both courts were courts of coordinate situation. If the High Court gives a decision, another High Court takes a course different from the course that had earlier been taken by another High Court. There's nothing wrong with that at all. So for me, there has not been a categorical pronouncement on the issue raised by Justice Dennis Ajay, whether an ex-parte application can be applied for under the Public Order Act. And I think that sometimes the circumstances of the occasion may warrant fact, what the provision says is that the police, when it has indication that a prospective demonstrator seeks to proceed with the demonstration, may apply to the High Court for an order. Now, when it applies to the court, the manner in which it applies, whether it's by ex parte application or notice is not indicated in it, that is what warranted the early application in the Justice Dennis, the matter that's authenticated upon by Justice Dennis J. So I think that there ought to be a categorical pronouncement on the issue, but of course, the relevant circumstance the court found itself in the matter in question was very material.
Nominee.
Was very close
you
to
have
Christmas.
2 judgments from Court of Coordinate Jurisdiction saying 2 different things. The question is, what is your own? You want your own attitude towards that?
Gentlemen, I am inclined to go on notice in such circumstances in accordance with the principle of fairness. I'm a fair-minded practitioner. I like to do that. But I think that sometimes, if the police find itself with the possibility of a demonstration in the course of the Christmas holidays, say 29th December or 3rd January, and the courts are going on a break in accordance with CI 47 from 23rd December, I think the police may be compelled to go ex parte. But that ex parte application ought to be made rarely, very sparingly.
Yes, Honorable Governor.
Thank you, Mr. Chairman. Congrats, Godfred, for the nomination and the elevation to the big position of Attorney General. Now, I'll start with some of the cases that you've listed regarding your CV. I see that many of the cases listed are related to social legislation cases. And I'll ask these 3 in one question. What are the challenges associated with the regime of subsidiary legislation in Ghana? What reforms would you undertake regarding subsidiary legislation? And do you agree that we should have an act on subsidiary legislation? And how soon will the bill be brought to Parliament? Do you have the questions? 3 in 1. Yes.
So we have challenges with subsidiary legislation.
Challenges associated with it.
Whether
yes.
I think there ought to be legislation and how soon.
Yes, reforms and how soon you think that we should have an act.
Right, sure.
Yes.
Everyone, the challenges with subsidiary legislation are contained in the formulation of Article 11, Clause 7 itself. It says any other rule or regulation made by a person or authority under a power conferred by this Constitution or any other law shall A, be laid before Parliament, B, published in the Gazette on the date laid before Parliament, and C, shall come into force at the expiration of 21 sitting days after being so laid, unless Parliament before the expiration of 21 days announce the order, rule, or regulation by the votes of not less than 2/3 of all members of Parliament. Mr. Chairman, the first problem is with Article 11, Clause 7, Paragraph C, that Parliament is divested of any power or authority to amend a subsidiary legislation once it is laid before the House. So, Parliament, in accordance with the ratio of the Supreme Court in some of the cases that I conducted, which my very good friend, the Honourable Member, has alluded to, the Charles Matricule and Atenjo.
Honourable nominee, is it the problem with the law or the interpretation placed on it by the Supreme Court?
Very well. So the first problem is with the import of Article 11, Clause 7, Paragraph C, that Parliament does not have the power at all to make any amendment or change or alteration to a subsidiary legislation laid before the House. Because under Article 11, Clause 7, Paragraph C, the subsidiary legislation comes before the House, Parliament does not do anything at all to it, and unless Parliament exercises its powers to annul it, and the annulment process is so rigorous, it requires 3/4, or is it 2/3? 2/3 of the members of the House.
So what's the meaning of 2/3? If you say rigorous, what's the meaning of 2/3 mathematically relative to 275?
My crude mathematics will indicate that 2/3 would be
90 times 2.
70%.
180 plus 75%.
75%.
Yeah.
Of the composition of the House. So if the House is composed of 275 members,
It's less than 75.
Yeah, so 2/3
a little under 70.
pardon me,
A little under 70%.
a little less. Okay, very well.
Yeah.
I can see that the lawyers in the House were struggling with the mathematics.
The lawyers are many.
Yes, the lawyers are many. So, gentlemen,
There's no legal mathematician here.
gentlemen, so I think that in itself will present a problem, or presents a problem, because you find a situation where a subsidiary legislation is laid before the House. Clearly, there are certain parts of it which may even be obnoxious or may even be unacceptable, but the House cannot do anything at all unless they exercise their 2/3 majority to annul it. And I think that ought to be looked at. Indeed, the Attorney General, my former boss, Madame Kufu, considered a committee to examine certain provisions of the Constitution which ought to be amended or required urgent amendment. The committee was composed of myself as chairman, eminent persons like Professor H. Kwesi Prempeh, Mr. Kutuampao, and Mr. Obiama himself, Honorable Obiama himself, for those who remember, and 2 state attorneys. And we all came to the conclusion that Article 11, Clause 7C required need for urgent reform. And so it was penciled down for amendment by later on. So I think that first there has to be an amendment of Article 11, Clause 7 to permit the House to, if it considers any provision in the statutory legislation unacceptable, to be able to make certain changes, rather than the LI or CI coming into force and subsequently that CI will have to be revoked. And then also the number for annulment, the 2/3 majority. With all respect, we find it to be a little bit too strenuous, because it will be almost unachievable unless there is virtual consensus in the House for us to have an amendment of amending the Constitution. I think that with all respect, that has also to be looked at. Now, again, I also think that there ought to be a legislation governing statutory legislations in general. And that legislation, with all respect, has to even specify the circumstances within which a minister who has been given power to enact an LI, or an authority who has been given power by any enactment to come up with regulations to perform that function. Otherwise, sometimes you may have certain provisions of the law requiring that a minister or an authority comes up with a subsidiary legislation, and that power will not be exercised at all. And that may be detrimental to the interests of the nation. So if there's a provision, if there's a legislation governing subsidiary legislation generally, I think that it will be very helpful. And the question as to how soon. First, 2 points. The first point is the humble approval of this Honorable House of my nomination. If this House respectfully approves my nomination, I can team up with honorable members like Mr. Obiama to consider the proposals for presentation of a Legislative Instruments Act for this country.
Okay. Let's move into more issues which probably may involve you. The first one is you're a member of the board of PPA. And would you want to tell us the role you played on the board and the suspension and termination of the appointment of the previous CEO of the authority?
Okay. Well, gentlemen, in the first place, the termination of the appointment of the SWA Chief Executive Officer of the PPA Board, Mr. Yeboah, was done by His Excellency the President. Was done solely by him, and it was in exercise of his powers under the law. He considered the reports of the Commission on Human Rights and Administrative Justice, and he had no hesitation at all that, having regard to the charge reports, the best step in the interest of the nation was to terminate the appointment of Mr. Yeboah. And I think the President ought to be commended for the swift and decisive manner in which the termination was done. And the charge report was also implemented. Now, regarding the very matters which also led to the issue before charge, it's also important to place on record that it took the board by surprise, and the board itself was very shocked. Indeed, we are grateful that the inquiry that was conducted by charge did not find anything implicating of any other member of the board apart from Mr. Yeboah. And I would refer to part of the decision of charge. The honorable member says, I have a lot of documents. Indeed, I have a lot of documents, and that shows respect for this honorable house. The charge decision was dated 27th October 2020. And the committee will find that it was entirely an examination of the conduct of Mr. Yeboah. The Office of Commission on Human Rights and Administrative Justice actually spelled out the issues identified by the investigation at page 36 of the report. And all the issues, just for the record, if I may quote, centered around the conduct of Mr. Yeboah. No other member of the board was implicated at all. And for the record, I was also not implicated at all. It says the first issue was whether or not the respondent established Talent Discovery Limited a few months after he was appointed CEO of PPA. 2, whether or not respondent had resigned as director of TDL at all material times. And 3, whether or not contracts awarded to TDL by ministries, departments, and agencies and other public procurement entities between June 2017 and August 2019 were mainly through single source and restricted tender. 4, whether or not TDL was involved in the sale of state contract awarded to it. 5, whether or not the respondent used his office improperly for the benefit of TDL and other companies affiliated to him. 6, how does the respondent explain the volume of cash that passed through his bank accounts between March 2017 and August 2019? And then finally, whether or not the respondent put himself in a position where his personal interest conflicted or was likely to conflict with the performance of the functions of his office. Gentlemen, for the record, the PPA board was written to by the Commission on Human Rights and Administrative Justice. Each of the members of the PPA board, including my humble self, wrote to the Commission on Human Rights and Administrative Justice explaining our involvement, if any, in the matters that the Commission had indicated they were going to deal with, which I've already read. Gentlemen, the charge itself came to the conclusion that the PPA board had complied with all the, charge itself came to the conclusion that the PPA board's conduct did not involve any breach of any law at all, and that the only breaches in question were by the gentleman in question, Yeboah. And I say so because after we had set out the role of the PPA board in the grant of approval for research tendering and single sourcing, chart at page 176 says the commission agrees with the respondent that the board of the PPA, of which respondent is a member, is not responsible for shortlisting companies. Same is the lawful duty of procurement entities. The law makes it the duty of procurement entities through their relevant entity tender committees to consider and assess the qualifications of tenderers. However, that is not the issue at stake here. The issue is about the respondent's public capacity role as CEO and board member participating in the decision-making process on applications involving companies he has significant private capacity, financial and relational interest in. I'm sorry. So the point that is being made here is that, shared from this page that I've quoted, came to a conclusion that it was definitely not the board. I mean, it was definitely not the PPA board's duty to shortlist companies or to evaluate tenders or to conduct a tender. So, no conduct on the part of any board member of the PPA was held to be in violation of any law at all. And then SHAD itself indicated that the only issue here, the main issue here, was whether Mr. Ibeji had violated his public duty as CEO and board member by participating in certain decisions of the board involving companies he has significant private interest in. And then they made certain findings. The findings of SHAD are contained at pages 181 to 182. And none of the findings implicates any board member at all, including my humble self. The first finding talks about time discovering cooperative social. Just also add, even this SHAD observation that the PPA board's role is not to conduct a tender and not to evaluate tenders and just to approve a process. It's also relevant for the earlier points I made about Japan, whereby the PPA board just approved of the method and then the entity will conduct a tender. And when you conduct a tender, it controls the process, which includes setting out the rules for the tender.
Thank you. The last one, what led to the termination of the PDS agreement, if you have any information on that?
But what led to
the termination of the PDS agreement? PDS agreement. Yes, we've moved on from PDS.
Well, that's a very. Okay, so I'll just comment briefly by saying that when the new Patriotic Party government took office in January 2017, there had already been commenced a process which would result in private sector participation in power supply or power distribution in the country. Now, that process had actually resulted in about 6 foreign firms being shortlisted. An essential ingredient of the process was for local participation, and I think that the SO administration had set out a requirement of 80% to 20% in the sense, so 80% foreign participation, 20% local participation. And so when the MPP government took office in 2017, it continued the process. Of the foreign firms, one of them qualified on no accounts. And
Chairman, sorry, Mr. Honorable Nominee, just to enrich it because this is a meeting of record.
Yes.
When the MPP took power, contextualize it with MIDA.
With MIDA?
Yes. The Millennium relationship with the United States of America.
Sure.
And the fact that, just for the record.
That's fine. That's for the record. The private sector participation process itself was sponsored by the Millennium Challenge Corporation of the United States of America. And for that purpose, an entity called Millennium Development Authority had been set up, had a board, and what have you. So Miracle of Philippines is a company which Meralco of Philippines is the company which emerged the winner of the competitive tender process. But the only alteration or amendment of the rules which the MEP government ensured was to boost local sector participation and required that the foreign firm which won will enter into again a consortium with local participants, and the quantum was increased to 51%. The local sector participation increased from 20% to 51%, with foreign being 49%. Meralco formed this entity called PDS, and that's the vehicle. PDS was composed of Meralco plus other local companies. Now, conditions precedent were set out in the various transaction agreements. There were two major transaction agreements: lease assignment agreements and bulk supply agreements, executed between Electricity Company of Ghana and PDS, Power Distribution Service Limited. Mr. Chairman, the government of Ghana, acting through the Ministry of Finance, also executed the GSA agreement with PDS. Mr. Chairman, the conditions precedent to the transfer of the assets of ECG to PDS were 41. 5 of them were very essential and indispensable. Now, one of them, Mr. Chairman, was the requirement of the company PDS to produce what we call security. And the security was later on determined to be a demand guarantee from an insurance company for the transfer of assets to PDS. Mr. Chairman, a date 1st March 2019, if my memory serves me right, was set as the date for transfer of the assets. On 27 February 2019, PDS furnished what purported to be a demand guarantee from an insurance firm described as Output Insurance of Qatar. Mr. Chairman, ECG sought to confirm the authenticity and validity of the demand guarantee. Because of the constraint of time, ECG actually indicated to PDS that it was going to confirm the demand guarantee in form, but not in substance, and reserve the right to conduct further processes or investigations to ascertain the validity of the demand guarantees. The Chairman, a letter dated, and once again I have some documents that effect. Chairman, a letter was written by ECG to Output.
Chairman, we appreciate that the nominee is detailed, but you see in your answer you said condition precedent.
Yes.
What our honorable colleague wants to know, what informed the abrogation? As I understand.
The termination.
Yes.
Mr. Chairman, what
the termination,
what,
sorry, the termination.
Yes, that's what I'm alluding to. But the termination was informed by the failure of the demand guarantee.
Okay. And
therefore, I must, with all respect, take just about 5 minutes to explain. Mr. Chairman, so the letter was written by ECG, dated 28 February 2018 to Output Insurance, and it sought to confirm the demand guarantee. No reply was elicited from Output Company. And then ECG wrote another letter dated 15th March, again to Output Insurance. No reply was elicited. The Chairman, on 13th March 2018, Output purported to confirm the demand guarantee. And it says, but there's a letter confirming it, dated 13 March 2018. The letter is here. I just find a little print to read. The Chairman, ECG appeared not to be satisfied with the confirmation or purported confirmation by Output, because the letter was on the face of it signed by a middle-ranking officer of Output Insurance. ECG got in touch with our mission in Qatar to physically ascertain from the offices of Output whether such a letter has been issued. And then, surprisingly, Mr. Chairman, in the course of it, by a letter dated 16 July 2019, Output wrote through its chief executive denying issuing any demand guarantee at all. Output further indicated that it did not even have the capacity to issue such demand guarantees. Further, the officer in question had forged the earlier letter purporting to confirm the demand guarantee. Also, as per the laws of Qatar, Output could not even have issued such a guarantee because it required confirmation by the Central Bank of Qatar. Chairman, this indeed took the President by surprise. The President thus constituted a team to go to Qatar to ascertain the truth of all these matters. The team was led by the Minister for Interior, then Mr. Ambrizeri, had myself as a member, had other members of the Ghana, had some members of the Ghana Police Service also as members, lawyers of Ghana. Chairman, indeed, we met all the top executive of Output Insurance, the chief executive officer, their lawyers, and we also met their chairman. They confirmed the truth of all the matters contained in their letter repudiating the demand guarantees. And that our report confirms all these matters. They further confirmed that the officer in question had, by a letter dated 21st July 2019, been suspended without any pay at all. The President was very concerned because assets of the nation worth about $3 billion were at stake. And therefore, if there had been a failure of an essential condition precedent, which more or less had the effect of guaranteeing the transfer of the assets of ECG, then action had to be taken promptly. ECG suspended the lease assignment agreement as well as the bulk supply agreement. And then the Minister of Finance also suspended the agreement and executed with PDS. And that was to pave way for further investigations. Indeed, the government of Ghana went beyond it and took the steps of engaging the Millennium Challenge Corporation in the United States of America. And that delegation was dispatched by the President, led by the Minister for Foreign Affairs and the Minister for Finance, and I was also a member, and other persons, members of government also part of the team. The Chairman, our point was just simple, to ensure that the assets of the country will be properly protected and nothing else. In the course of time, the Millennium Challenge Corporation itself had also conducted their own investigations. The Chairman, and the report was by an entity called FTI Consulting, dated 30th August 2019. And their report, with all respect, made for very interesting reading. And they indicated at page 19, so when the font size is very small, that's why sometimes I struggle, I'm sorry, that real authority, that based on our review of the document, Output does not seem, that Mr. Nuri is a gentleman, the rogue gentleman who had executed all those documents on behalf of Output. It does not seem that Mr. Nuri was authorized to execute the guarantees, although the technical document authority list includes Mr. Nuri as an authorized signatory to technical document. It fails to define or detail what is meant by a technical document. Then it further went on to say that while there was no provisions in local law that set out the concept and doctrine of apparent authority. So the FTI company went ahead to make the finding that even though the gentleman who had signed the letters on the basis of which the demand guarantees had been allegedly issued by Output did not have real authority under the laws of Qatar, the government of Ghana could proceed against the insurance company in Qatar on the doctrine of what it called apparent authority. And that apparent authority was per a decision of the court of Qatar. Now, Chairman, the absurdity to all of this was that the courts of Qatar did not apply the doctrine of stare decisis. They did not. Secondly, it would also have been, with all respect, a little bit incongruous and irresponsible for the government of Ghana to proceed all the way to Qatar to engage in litigation to confirm the validity of a demand guarantee based on a decision of a court of Qatar which was not binding on the court of Qatar. In the face of all of this, after about 3 or 4 months of an opportunity given to PDS to produce another valid demand guarantee, and same had not been duly taken, the government of Ghana, or ECJ, decided to terminate the agreement. So this, with all respect, constitutes the material fact resulting in a termination of the demand guarantee. And I think that it was very proper and right in the circumstances.
Very well.
You have a date of termination?
Yes, that's the one.
For the PDS agreement. Just quote it for our purposes. Thank you.
That's the one. Yes, that's the one is dated 23rd October 2019. 23rd October 2019.
Right.
Thank you very much, Mr. Chairman. Mr. Chairman, the Honorable nominee is accused of leading the effort to disenfranchise voters in the Central Kofi, Kafo, Lolobi areas in the voter register. What do you say to this?
I think it will be very unfortunate for anybody at all, with all respect, to characterize the role I played in ensuring a preservation of the right to vote of the whole
member, let me remind you of Order 93.1 so that you'll be guided in your comments. Reference shall not be made to any matter on which judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. So, whilst I'm listening keenly, if I have to stop you, I will.
Yes, I am very mindful of that, and I think that I must place on record that the decision in the Hohoi matter, what we call the SAL matter, it is ex-party Attorney General, was an application filed by the Attorney General to quash a decision of the High Court in a matter that has been filed by 5 residents of Hohoi, led by Professor Margaret Kweku. That decision has been a decided part of a review application by the respondent, Mr. Professor Margaret Kweku, led by Mr. Chatuchikata in the Supreme Court. But just by way of interest, I would say that indeed it will be unfair for any person to say that I led the effort of the people of Hohoi to disenfranchise. If anything at all, it's the opposite, which is the case. I ensured the preservation of the right to vote of the people of Hohoi, because the SAL area, as far as I'm concerned, clearly has, by dint of CI 128, Representation of People's Parliamentary Constituencies, been placed in the Buem constituency, and not Hohoi constituency. So, if the committee looks at page 71 of CI 128, it shows that the SAL areas had been clearly placed under Buem in Oti region and not Hohoi in the Volta region. So when indeed an application was filed by them and others made to restrain the Member of Parliament elect for Hohoe at that time from being sworn in. Of course, the Attorney General was also a party with the application. The Attorney General was compelled to file an application in the Supreme Court because to start with the matter that went to the High Court, who, insofar as it affected the right to be sworn in by the Member of Parliament of Hohoe, should not have been filed in the Human Rights Court because it was an election petition. The Attorney General felt concerned and acting in accordance with my understanding and conviction, I filed this application in the Supreme Court. And the Supreme Court unanimously upheld my submissions and quashed the orders of the High Court rule. But the main point of concern is that the people of SAR are not by law required to vote in Hohoe. They have been placed in Buem in the Oti region. And I remember making a submission in the Supreme Court that if there were any group of people affected, it should be the people of Buem. And therefore, I will lead efforts to ensure that the SAR people will vote in Buem constituency. And if by the grace of God, this honorable court, this honorable house approves of my nomination, I will, in accordance with that submission, ensure that the people of SAR vote where they are supposed to vote, that is in Buem, and not Hohoe.
Thank you, Mr. Chairman. Mr. Chairman, after the Ayawaso West Wobom by-elections, the government constituted inquiry into what happened after the by-elections. Now, the Short Committee issued their report, and the government issued a white paper which rejected most of the recommendations made by the Short Committee. That white paper was signed by the Attorney General. Do you think that rejection by the government, that decision by government, is in the interest of good governance?
Okay, Mr. Chairman, I would say with all respect that to start with, the prerogative of the President to issue a white paper stating a position on the findings of a commission of inquiry is in the best interest of good governance, because that is actually the purport and effect of Article 280 of the Constitution. And Article 280 Article 280, Clause 3, stipulates as follows: the President shall, subject to Clause 4 of this article, cause to be published the report of a commission of inquiry together with the white paper on it within 6 months after the date of the submission of the report by the commission. Then Clause 5, also Clause 4 first, says where the report of a commission of inquiry is not to be published, the President shall issue a statement to that effect, giving reasons why the report is not to be published. Clause 5 says, a finding of a commission of inquiry shall not have the effect of a judgment to the High Court, as provided under Clause 2 of this article, unless, and B for me is most relevant, the government issues a statement in the Gazette, in the national media, that it does not intend to issue a finding upon the report of the Commission, whichever is the earlier. So, with the greatest respect, it shows clearly that the President has been mandated by the Constitution to issue a white paper stating a position on the report of a commission of inquiry. And the precondition to the findings of a commission of inquiry being construed as a judgment to the High Court is actually predicated on the issuance of white paper. And for that matter, if the President does not intend to do so, he ought to state it. And if he does not do so, the report does not become judgment to the High Court. Now, I say that the Constitution has cast provisions in this way to show that the work of a Commission of Inquiry itself is part of the executive functions of government. So a Commission of Inquiry, a Commission of Inquiry's work is part of the manner in which the executive powers of government are exercised. That must be construed. The fact that the report of a Commission of Inquiry can, subject to certain conditions, become a judgment to the High Court does not derogate from the basic fact that the work of a Commission of Inquiry is part of the exercise of the executive powers of government. So it's actually government, it's part of the government work. Now, the government was compelled to issue a white paper assigned by my former boss, Madame Goekufu, and the reasons have been stated there. And the committee will see that the reason why the government was compelled to indicate in a stencil its acceptance or rejection or partial rejection and partial acceptance of the report is on account of the manner in which the work of the Commission of Inquiry itself was done. So, in the greatest respect to the membership of the committee, one of them, my former lecturer, Professor Rita Mesa-Bosu, and the other, a very eminent jurist, in short, and the other two, a very important or a police officer who served the nation well, former IGP. Some of the findings were internally inconsistent. So, to start with, the commission represented, as far as I'm concerned, a very bold initiative of a government.
Honorable, I think you're elaborating. Can we come to a conclusion on this matter?
I think that I might just try to indicate some of the inconsistencies. So for instance, where the
document is available to
it's available, fine. So some of the findings were inconsistent, and that has. And then also, I may also just to indicate the boldness initiative, refer to the Hansard of this honorable house. There is the record of proceedings of parliamentary debate dated 7 July 2011, whereby after the Atiwa incident, the Attorney General was compelled to appear before this honorable house and justify why certain actions in the nature of either Commission of Inquiry or prosecution of the members of persons found to have misconducted themselves in the Atiwa incident were not prosecuted. And indeed, the Attorney General then, Mr. Matiyamidu, clearly refused, with all respect, to either institute an inquiry or to prosecute the persons who had been injured and or were the victims of violence in the Atiwa incident. And stated here at page 2360 of the Hansard of 7th July 2011. The column, this honorable house, it has oral answers. Well, the page is 23.
We call it column.
It's column 2360. Okay, I stand to correct it. The people of Wenchi will be angry with you if you say that. so page 2360, the column 2360. You find that Attorney General justifying why actions should not be taken after the Atiwa violence. And for that matter, I think that the President who instituted this Commission of Inquiry and accepted some of the findings ought to really be commended for the bold initiative. But I've explained why it rejected some of the findings. And it was compelled to do so because of the internal inconsistency and contradictions in some of the findings.
Yes.
My second question. Mr. Chairman.
This is your third question.
Oh, the second one was follow up.
How can what the IOA should be a sequel to South.
My next question has to do with legal education in the country. In the past, we only had Legon and Tech to offer LLB degrees. So the existing facility could accommodate them to do the professional law degree. But now we know that JIMPA is offering a LLB degree program. Cape Coast is doing the same, and other universities are offering LLB degrees courses. But we have not done much to expand the facilities at the professional level. Will you consider pushing for those universities to offer the professional courses? Apart from that, what would be your suggestion to reform legal education in Ghana?
I'm very useful, and I recognize that the honorable member is very passionate about legal education. Indeed, my appearance before the committee in 2017, I think the honorable member asked a question on the same lines, and he's taken to his passion. I think he wants to be a law student, and I'll be interested in taking one as a pupil at the appropriate time. That's what I think. Legal education has come a long way. Prior to 2015, the legal education professional legal education was just run on the lines of it was structured in this way, a 2-year course with 12 courses spread over the 2 years. Then in 2015, there was the introduction of entrance, examination, and interviews. In 2018, pursuant to the professional law course regulations, the interview aspect of it was removed, but of course the examination was preserved. Then there was an attempted restructuring of the course to be on these lines: 1 year law course conducted in the classroom, and another 1 year conducted outside. Conducted outside in the sense that there will be pupillage of 6 months in a legal department, firm, or the judicial service. By 2020, the General Legal Council has scrapped that arrangement too. But, Mr. Chairman, it is important to say that all these measures were taken in the interest of boosting the quality of practitioners or quality of products that come to law school. And I'm also happy to say that there has been a dramatic proposed change in the structure of the law program. So there has been there's been drafted a proposed amendment to the Legal Profession Act, because that the change will require an amendment not just to regulations, but this one to the Act itself, Act 32 of 1960. So as to permit the professional law course from being run by the various faculties which undertake the LLB, that's the Bachelor of Laws program. And I think this represents a very bold initiative, and which will go a long way to expanding access to law school. Over the years, I have always held the view that the difficulty in having access to law school was occasioned by the disconnect between the manner of regulation of the LLB program and the manner of regulation of the professional law course. Whereas the LLB program was regulated by the accreditation board, National Accreditation Board, the professional law course was run and regulated by the General Legal Council. So you find a situation where there will be in existence many faculties, Cape Coast, Kumasi, and Accra, many of them, and some even Kumasi having campuses in Mampong, what have you, running LLB programs. And eventually, over 1,000 students will be unleashed onto the scene every year. The General Legal Council will still maintain its grip over the professional law course and have only these 3 campuses, Legon, the old Mapala campus, as well as Kumasi. Of course, there was a limitation in infrastructure. So part of the means to also boosting the fiscal access is to ensure a completion of this law village project, which has been earmarked and I think it's supposed to be around Legon or Pesek, for a long time. So, Mr. Chairman, I think that an amendment of the Law Profession Act, the Legal Profession Act, will actually lead to a resolution of the long-standing problem of access to law school. And I'm happy to say that there's a draft bill. I believe that if this Honorable House, by the grace of God, approves of my nomination, I will help in ensuring a swift passage of the law and will also, apart from that, ensure a completion of the Law Village project. And that will really resolve all the problems, including your giving vent to your desire to be a lawyer.
Yes, Reverend.
Thank you, Mr. Chair, and congratulations, the learned Attorney General and Minister for Justice Designate. What is your legal inclination on the advocacies calling for a capping to be put on the number of judges at the Apex Court?
Grateful for the question. I think that the question itself has implications for the independence of the judiciary. Indeed, the considerations of a cap or a limitation on the number of judges that, or justices of the Supreme Court that a president may appoint has every relevance for the independence of the judiciary. Because there's worry about a president seeking to maintain its grip on the judiciary, appointing justice on the Supreme Court of Ghana. Now, this country has had a convention of maintaining, even though there's no limitation, a number of about 15 justices on the Supreme Court at the time. Mr. Chairman, I think that the issue can be addressed first and foremost through the appointment processes of the Supreme Court Justice the Supreme Court of Ghana. The appointment processes are set out in the Constitution. And my view is that if indeed all parties relevant to the process were to perform their task seriously and faithfully, I think that inherent in that will be that check on a president from abusing his or her powers. So Article 144 plus 2 stipulates that the other Supreme Court justices shall be appointed by the president, acting on the advice of the Judicial Council, in consultation with the Council of State, and with the approval of Parliament. So the Chairman will see 4 main parties relevant to the appointment process of a justice of the Supreme Court of Ghana. The first is the advice of the Judicial Council. So the Judicial Council itself will have its inbuilt mechanism for ensuring a thorough approval of persons, or a thorough scrutiny of persons who may be advised for appointment. I think that would be the first check. And secondly, there is also required to be consultation with the Council of State. Even if the Council of State is seen to be part of the executive, which some theorists will disagree, and I indeed take the view that yes, they are. I think that they can also be a useful check in terms of constitutional arrangement that we have in the country, even if they default on their duties.
Chairman,
the ultimate duty.
Chairman, if I can indulge you, just honorable nominee, you are relying on Article 144. You are entitled to 8. and in your opinion, you are emphasizing on the appointment
process, yes,
relative to the question that our colleague asked. Just read Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. What can the appointing authority do relative to this provision? Right. If you marry it, we can enjoy the intellectual discourse on this matter. Thank you.
So, Mr. Chairman, Article 128 does not place a cap or limitation on the number of Supreme Court justices. It only sets a minimum, and that minimum is 9. So, the Chief Justice plus not less than 9 justices of the Supreme Court that constitutes the Supreme Court. Mr. Chairman, there is no upper limit, and the upper limit is determined by the substance of the day. Mr. Chairman, that is why I'm saying that I consider the appointment process to be very material. And I'm saying that in order to curb a president who would want to appoint as many justices to the Supreme Court as possible by way of a subtle manipulation of the Supreme Court, the various parties involved in the appointment procedure as set out in Article 144, Clause 2, will be very material. And I'm saying that the first party is the Judicial Council. So the president does not, with all respect, get up and appoint on his own. The president cannot appoint on his own. The president's appointment process, with all respect, will even be considered to be perfunctory because it is pursuant to activities engaged in by this important element. And the first institution is the Judicial Council. The Judicial Council does not advise for appointment. The appointment cannot commence at all. So if indeed all these parties relevant here were to take their constitutional duties seriously, with all respect, and ensure that even the case or the situation of a president appointing does not arise, there will be a check or there will be a cure to the problem envisaged by my very good friend, honorable member. That is the point I'm making. And I'm saying that the ultimate word is with this honorable house. Because the appointment, the advice, the consultation, and whatever you cannot come into effect without the prior approval of Parliament. And therefore, I consider this honorable house, house's rule very important. So, even without amending the Constitution to place an upper limit or a cap on the appointment, on the number of Supreme Court justices, there is an internal check set by the Constitution itself for such a restriction to be achieved. Mr. Chairman, I may also add that the problem or maybe the need to appoint many Supreme Court justices has also been rendered necessary by virtue of the combined jurisdictions of the Supreme Court. The Supreme Court is a constitutional court, it's an appellate court, it's a review court, it's an election petition court, and it's also the court set by Article 135 for giving approval for the release of official documents and what have you. So if indeed there is a right of appeal from every decision of a high court to the Supreme Court, apart from matters which have emanated from the circuit court, clearly the committee will see that there's a need for us to have a lot of Supreme Court justices, because unlike certain countries where the Supreme Court is just a constitutional court, or maybe there's even a constitutional court as distinct from a Supreme Court, in this case, it has combined jurisdictions. So one of the processes that I will also, with all respect, try and seriously pursue by way of law reform is to ensure that the Supreme Court itself exercises its own judicial powers to control the adjudication of the plenty cases that come before it. There's nothing wrong, with all respect.
Chairman, with your indulgence, the longer you engage us, the more the period we'll spend with you. What we want from you,
right,
if you want to take a middle ground as I understand you, you are saying that the appointing authority, including Parliament,
Yes.
can exercise a persuasion to limit the numbers. Now, your second argument is that given the multiplicity of the role of the Supreme Court, you are for open-ended. Where do you stand? Are you for capping or not?
Mr. Chairman, I think the present arrangement to the Constitution is sound, is proper, and I've not faulted in any way. And I think that there ought to be rather a strengthening of the roles played by the various.
Are you for capping, limiting numbers to appointment to the Supreme Court as it pertains in the U.S., or you are for open-ended? Just give us an answer for that.
Having regard to the multiplicity of jurisdiction of the Supreme Court, I am not for capping. I am for a strengthening of the rules of the various institutions.
I am now going to limit you, because if I leave you, we're going to spend the whole of the day here. So, yeah.
Honorable Chair, you may indulge me to situate my last question in context and with particular regard to Article 35, Clause 5, and with your indulgence, I read, under the directive principles of state policy, the state shall actively promote the integration of the peoples of Ghana and prohibit discrimination and prejudice on the grounds of place of origin, circumstances of birth, ethnic origin, gender or religion, creed or other beliefs. And with due regard for this provision, to refer the honorable nominee to Section 104, subsection 1B of the Ghana Criminal Code of 1960, which states that unnatural carnal knowledge with consent is considered a misdemeanor. In respect of this particular provision, Honorable Leonard Attorney General and Minister for Justice Designate, some activists have posited that this particular provision I made reference to is anachronistic and therefore not sufficient to fully address the emerging matters of LGBT. And in that position are even advocating for further strengthening of our laws to be able to fully address these matters. What is your view on this matter, and what would be your advocacy for the strengthening of our laws to fully address matters of LGBT?
That's one. I take the view that the provision of the Criminal Offences Act does not offend the Constitution at all. I think that, yes, there are cultural rights recognized by the Constitution. My personal view is that it is only when the laws are applied in a way discriminatory of a particular people, group of people, that you can allege or assert unconstitutionality. I take the view that the decision of the Supreme Court in the James Kobna Bonfe and the Attorney General matter recently regarding the National Cathedral itself is an affirmation of the fact that even though there are multiplicity of religions in the country, freedom of religion, and what have you, any decision by a president to promote a particular religion is not discriminatory. In the same way, any practice of a people which seeks to protect its customs and values cannot be deemed to be discriminatory. And for that matter, I would agree that the section of the Criminal Code is not discriminatory at all. I think that what is required is a free society that will not unnecessarily victimize persons, but that is not to be construed to mean that the state cannot put in place certain laws which protect its customs and traditions of the people.
Thank you, Mr. Chairman. That'll be all from my side.
Yes, Honorable Susu.
Thank you very much, Mr. Chairman. Honorable nominee, I would love to find out whether the data bank was involved in the Ejapa royalties deal. Were they one of the advisors?
Yes, Data Bank was jointly appointed with Imara Corporate Company as a transaction advisor.
As a follow-up, given the fact that the then Minister of Finance is strongly associated with Data Bank and is known to be a co-founder and a former director and someone who could be said to have a beneficial interest in Data Bank being appointed as advisor to a transaction like this, don't you think that that may sin against the rules in Article 284? And with the permission of the chair, if I may read, it says that a public officer shall not put himself in a position where his personal interest conflicts or is likely to conflict with the performance of his functions of his office.
I think so. Certain fundamental facts have to be spelled out. Now, Data Bank was founded or co-founded by Mr. Kinufrata, the former finance minister. Now, Data Bank has been engaged in various transactions, which are matters of public record, involving the government of Ghana. In the 90s, they engaged in a transaction involving Anglo Gold Ashanti and the government of Ghana. In the 2000s, in the President Kufuor era, they engaged in various transactions with the Ministry of Finance as well. In the Mills Mahama administration, they engaged in various transactions with the Ministry of Finance as well, including Eurobond and what have you. And so, Mr. Chairman, the question that necessarily arises is whether the mere appointment of the co-founder of such a company, which has been involved in transactions with the government of Ghana at every material time in the Fourth Republic, is automatically barred from continuing in the performance of its regular functions, just by virtue of the assumption of office of one of the co-founders as the Minister of Finance. The Chairman, that may seem to be a little unreasonable and a far-fetched conclusion to draw. The Chairman, if that were the case, I'm saying so and I'll address the specific matter centered on this transaction. Then an Attorney General who also had a law firm before assuming office as Attorney General, would it also imply that such an Attorney General, the law firm of that Attorney General, would also be prohibited from representing any ministry, department, or agency just by virtue of one of the founders of the law firm being an Attorney General? Of course, I don't find myself in that situation. The law firm I founded, Dami and Partners, I put it on hold. Before I got appointed, I was just appointed just around the time I founded. So there's nothing like that at all. So I'm not speaking for myself by making this allusion. But it is a notorious fact that every Attorney General had a law firm before becoming Attorney General. In this transaction, my scrutiny of all the documents, particularly the tender processes, the evaluation of the tender processes, does not show any violation of any aspect of the tender processes. And indeed, I do not see any allegation by any person to that effect. The Chairman, the special prosecutor, then, it would be very important to quote from certain aspects of the report that he himself prepared, which sought to suggest a conflict of interest situation, a finding of conflict of interest situation. Now, the special prosecutor stated at page 3 of the letter that he wrote to the president, the letter dated 16th October 2020 to the president, that the analysis of the risk, starts from page 2, the analysis of the risk of corruption and anti-corruption assessment in the bid selection process led to the assessment that the involvement of Imara Corporate Finance Limited of South Africa in the mandate agreement as approved by the PPA made the mandate agreement and transfer business agreement. I've addressed that one already. Then says the slowly, I'm sorry, because I'm reading that one. I'm saying, says the mandate agreement does not say how and when the decoy, Data Bank of Ghana, was to be paid by Imara for a contract reportedly won and performed jointly. This opaque arrangement in the contract and arising up to the PPA approval is what made the analysis of the risk of corruption assessment conclude that the process of the selection of the transaction advisors disclosed a reasonable suspicion of bid breaking and corruption activity, including the potential for illicit financial flows and money laundering in the arrangement of how the fees payable to Data Bank as a decoy, which was not approved under the PPA Act, are to be made. Respectfully, you find here very serious and severe conclusions made by the auditor, by the special prosecutor. And Mr. Chairman, these conclusions, with all respect, seem to be suppositions or inferences that the special prosecutor, drew from his assessment, which made the finding that the agreement did not have PPA approval. I've already explained why, in the context of the approval of registered tendering method, the Ministry of Finance has the full authority to determine the rules of the tender and to supervise the implementation of the rules of the tender. So, if indeed just by involvement of Data Bank, an allegation can be made that there was a reasonable suspicion, and mind you, with all respect, it is not a conclusion that there was bid breaking. It doesn't conclude so. It says reasonable suspicion of bid breaking. I think that he actually owed a duty to show how the rules set out in the tender processes launched by Data Bank, launched by Ministry of Finance, were breached and breached in favor of Data Bank. And he doesn't, with all respect, show how the tender processes, as I've indicated, were breached by Ministry of Finance in favor of Data Bank. So that is one problem that I had.
But don't you
then again, he also indicated towards the end that this assessment does not constitute an investigation, even though formal investigations or the suspected commission of corruption and corruption-related offences may arise from this corruption risk. It is not the work of a commission or committee of inquiry. So we find here the same prosecutor, after having made all these wild, with all respect to him, somebody because he's my very good friend. I go to his office and he knows it. He sometimes says that I'm one officer from Ministry of Justice who visits him regularly. When I used to consult him about a lot of things, say that it is not an investigation, it's not the work of a committee or a commission of inquiry, but at the same time, there's reasonable suspicion. I think that he really owed, or the office owes a duty to go beyond this report and after commence an investigation, even and to ascertain whether there was or there was not. Until then, there cannot be an allegation that there was conflict of interest. Now, conflict of interest, again, as is defined in Article 284, the situation where a public officer places himself in a situation where his personal interest conflicts with the performance of his public functions. The Constitution does not go beyond it to explain or indicate other elements of conflict of interest. Thankfully, SHAD has come out with certain guidelines for determining whether there's conflict of interest in a situation. And they allude to one where there's financial interest of the public officer in the transaction in question. Or 2, where financial interest can be imputed to other persons who are associated with the public officer. Or 3, where the public officer abuses his public office for private profits. Or 4, where the public officer abuses public information, i.e. breach of confidentiality and what have you. Then, SHAD proceeds in the same guidelines to provide 2 cures of conflict of interest. The first proposed cure is by a disclosure of the interest. And if the committee would note, and it is for this reason why they came up with the findings they did in the ABAJ matter. Secondly, where there has been a removal of the public officer from the transaction in question. Gentlemen, as I indicated, because of the lack of clarity with regards to the issue whether indeed by virtue of a public officer having an interest in a company, that company, whenever the public officer assumes office, should be prohibited from engaging transactions. I think I will recommend law reforms in that regard. I think that there ought to be a passage by this Honorable House of the Code of Conduct of Public Officers Bill. The Code of Conduct of Public Officers Bill has been prepared by the
Honorable
officer. Until
yes,
then, I don't see any conflict of interest.
Yeah, thank you, Mr. Chair. Again, when you look at the corruption risk assessment report on page 56, the last paragraph.
Is that corruption what?
Risk assessment report. The same report that he referred to.
Honorable Matiamidu's risk
56.
assessment report, yes.
On page 56. The last paragraph. This was a conclusion made by the special prosecutor. It says that a deeper analysis of the risk of corruption and anti-corruption assessment of the mandate agreement arising from snowballing by the Deputy Minister led to the discovery that Honorable Charles Edubwahi, the Deputy Minister, who appeared from the analysis of the risk of corruption and anti-corruption assessment to have been the overseeing Deputy Minister for this procurement process for the transaction advisors and purportedly signed the mandate agreement for and on behalf of the Republic of Ghana, knew or ought to have known that he could not commit the Republic to any contract, let alone sign the mandate agreement in the name of the Republic. And he made reference to Section 7 and Section 25.3 and Section 4 and Section 102 of the Public Financial Management Act.
Honorable Member, he has answered and referred to all these things earlier. So you may ask another question, please.
Oh, very well. Very well.
Honorable, so when he was dealing with the capacity question, those were quotes. What probably we didn't know was that it's the same quote you are referring to the Martin report, but he was on the capacity issue, referred to that.
Very well, Mr. Chair. Now, my second question borders on your role on the PPA board. Were you a member of the board?
Yes, Mr. Chairman, I was.
What was supposed to be your role on that board?
But my role was a member of the board to approve applications in accordance with the provisions of the Public Procurement Act at 663, primarily.
So what would be your response to the concerns that being an institutional rep on that board, you cannot completely extricate yourself from the PPA scandal because you were supposed to be the government's legal advisor on the board?
Right. Okay. Mr. Chairman, yes, I think even though I've answered that, I will go to the importance of the question and refer to the ABAJ ruling. And I've indicated that the ABAJ ruling came up with key findings. None of the findings implicated the board in any way. The findings centered around the personal conduct of Mr. ABAJ. And insofar as something he did on the board was concerned, Shad actually found, for an instance, that he even altered the minutes of the board of a particular day. So really, those were personal acts, and charge indicated for the record at page 176 that the key issue was about the respondent, that is ABJ's public capacity role as CEO and board member, participating in the decision-making process on applications involving his company. Indeed, the conduct of the board was not an issue before charge. I've also referred to 7 issues set for determination by charge. None of them bordered on the conduct of any other board member apart from Mr. ABJ. And even charge also, just for the record, held here at page 158. It says, this investigation abounds with evidence of many instances of the respondent, that's Mr. ABJ, not disclosing or recusing himself during board meetings. And then it says, secondly, we also see for documents, but the point has been made that clearly the investigation was, or the findings were about Mr. ABJ and not the board. And I would just for the record indicate that the PPA, as was found by charge, when it engages or approves of a research tendering method, only approves the method. It doesn't engage in a tender. The PPA does not select companies for a tender. It does not evaluate tenders. It doesn't select companies which win a tender. Those are done purely by the entities. And those entities were not the PPA at all.
Mr. Chairman, my last question borders on human rights. Under your watch as a Deputy Minister for Attorney General and Justice, we've had several human rights violations in the country. The first one, I would make reference quickly to some of our students, even though this may be in reference to legal education, but I consider it as a human rights matter, who were given a letter from the Ghana School of Law to Rwanda. They managed to finish their legal education. The president was even in Rwanda. There are evidence showing that, assuring them that he was going to do something about their condition, only for them to finish, come back to Ghana, and as we speak now, they cannot be given a post call. That is one of the major human rights matters I would want you to address when you eventually address this matter. Now, in the 2019 Human Rights Report by the United States Department Bureau of Democracy, Human Rights, and Labor, this was what they found as far as human rights is concerned in Ghana. It says that significant human rights issues included arbitrary and unlawful killings by the government or its agents, harsh and life-threatening prison conditions, violence against journalists, including assaults, death threats, and one journalist shot and killed, censorship of a free press, including arrests and the closure of 2 radio stations for ostensibly licensing irregularities, corruption in all branches of government, crimes of violence against women and girls, to which government negligence significantly contributed, infanticide of children with disabilities, criminalization of same-sex sexual conduct, although nearly enforced, and although barely enforced, enforced child labor. What would be your response, your policy response to some of these major human rights matters that were raised in this report, some of which we also know? We know of a number of police killings. Some of them are under investigation. But what would be your commitment to the fight for human rights in this country when you're given the nod?
Mr. Chairman, I respectfully observe that the matters referred to, or the instances cited by my friend and honorable member, relate to institutional weaknesses as far as I'm concerned. Because the honorable member was talking about violence against journalists, sentencing challenges, child labor force and all that. I mean, these are things that, with all respect, have been there and have been a result of the weaknesses of the Ghanaian society, and I acknowledge same. I think I can only make a firm commitment to the eradication of same. I myself have been a human rights practitioner for about 18 years already. I have many human rights cases on record, as I'm sure my friend already knows. So I can only, yes, but I will just resist the suggesting that it is as a result of our term or the past 4 years, or all these instances occurred in the past 4 years. I do not think that we can say that, or we can attribute these human rights violations to only the past 4 years. They have always been around, child labor and all. Of course, I see that Ghana's record in child labor has not been impressive at all. And I share your concern. There ought to be very urgent measures put in place to ensure a cessation of these human rights abuses. And I commit myself to it. Of course, the law school issue, yes, I've indicated the drafting of a bill that we did. The drafting of the bill occurred, and that represents a very huge or bold step to ensuring expansion of access to the law school. The drafting, the legal profession amendment bill, if passed by this House, will ensure that the faculties are empowered to carry out professional legal education themselves, and there will be a mechanism also struck to ensure proper supervision by a General Legal Counsel. And I've already indicated that we can only achieve a synchrony of access to the law school with access to the professional legal education by ensuring that there is a reform of the regulation procedure. It is incongruous to have law school regulated by General Legal Counsel and a different arrangement, i.e. vesting in the hands of the National Education Board for the regulation of the LLB program. There ought to be harmony between the two means of regulation of legal education.
Very well. Yes, Honorable Obama.
Thank you very much, Honorable Nomi. Congratulations, Honorable Dami. I have 3 questions. 1, the Supreme Court recently held in a number of cases that state institutions or entities that the state has some interest in, be it private or public, may use the services of private legal practitioners to prosecute their cases when they so desire. Notwithstanding that, the office is supposed to be the principal legal advisor to government and to represent the state in such matters. Recently, there was a situation where the Auditor General chose to defend a case using private lawyers. And the Office of the Attorney General also thought they should have acted for the Auditor General. To what extent do you agree or disagree with the position of the Supreme Court in this regard? Thank you.
Mr. Chairman, I am aware of the decision of the Supreme Court in Amegache against Attorney General, and that was way back in 2012 or 2011. I don't know whether the same decision my learned friend or honorable member is talking about, the same decision. So I think that's why the Supreme Court did not say that state institutions have the right to engage private lawyers. The Supreme Court rather held that it is only when the interest of the state or interest of government conflicts with that of a particular state institution that a particular state institution may engage private lawyers. So to start with, public bodies or state institutions are supposed to be represented by the Attorney General. It is the duty of the Attorney General to represent state institutions, and I'm not about, with all respect, to shed away some of my powers. I think that I will still agree that, yes, the Attorney General ought to represent all state institutions. That's the problem. It's only when, as I stated, the interests of the government conflict with that of an institution of state. Say the Electoral Commission. That is why the Electoral Commission has the power to appoint its own lawyers. Or SHAD. That is why SHAD also has the power to appoint its own lawyers. But a specific instance of the Auditor General, yes, I myself was the lead counsel for the Attorney General when the Supreme Court indicated that the Attorney General ought to represent the Auditor General. And that was consistent with the position that I had held. Because the Auditor General is part of the public services of government. Auditor General is a member of the Audit Service, and the Constitution says so clearly. The Audit Service Act also says so clearly. There is thus, with all respect, no warrant or basis for the Auditor General to be hiring its or his private lawyers. If the committee looks at Article 189, Clause 1, as well as Clause 2, it makes this quite clear. So Clause 1 says, there shall be an Audit Service Board, which shall consist of the chairman, and then the Auditor General, head of civil service. Then Clause 2 says the appointment of officers and other employees in the Audit Service, other than the Auditor General, shall be made by the Audit Service Board. So inherent in this provision is a recognition that the Auditor General is part of the Audit Service. The provision only says that the appointment of other members of the Audit Service, apart from the Auditor General, shall be made by the Audit Service Board. But to make this position quite clear, the Audit Service Act has stated in Section 2, the membership of the Audit Service. Section 2 of the Audit Service Act says members of the service. The members of the service are A, the Auditor General, and B, other persons employed in the service. So, quite clearly, the Auditor General is part of the service and therefore part of the public service of Ghana. Because Article 195 has stated the public services, Article 190, has defined the public services of Ghana to include the Audit Service. So clearly, you see that the Auditor General is supposed to represented by the Attorney General. And that is what the Supreme Court held in, I think, the first day of the hearing of the Professor Asari matter. The matter that Professor Asari had filed challenging the powers of the President to appoint, to ask the Auditor General to proceed on leave. On the first day, the Supreme Court held that I ought to represent the Auditor General. So I think it's quite clear. Also, perhaps the Attorney General has to boost his or her capacity to employ more lawyers so that he can effectively represent all members of the public service. That is all.
Thank you. My second question, please, can we look at Article 58 and 295, as well as provisions under Article 88 on the office of the Attorney General, which is a creation of the Constitution. See? In 88.1, a dual role is created for you as a Minister of State and the principal legal advisor to the government. And government is also defined under Article 295, I'm sure. You will be Minister of State, God willing. The President is the head of government, and government is defined to mean the executive, I'm sure. The President may have his political interest. You are an appointee of the President. You are going to be the principal legal advisor to the government. To what extent would your obligations to the President and the Constitution come to play should you be required to give a fair opinion on matters affecting the state to the government in that dual position? Thank you.
Mr. Chairman, I think that, yes, I recognize the point made by my learned friend, the honorable member of the House. Mr. Chairman, again, I would say that an Attorney General ought to act in accordance with the dictates of the Legal Profession Act, the legal profession, professional rules and of conduct and etiquette rules. And indeed, an Attorney General is supposed to act faithfully to the state. Attorney General is supposed to be the vanguard of the rule of law. It's supposed to be the protector, the first protector of the citizen as well as of the courts of Ghana. And I would say that in my track record, with all humility, will show that I act faithfully and impartially, regardless of political affiliation. And I can cite the case involving an honorable member of this House, Mr. Kennedy Yeboah, and when he found himself in a situation which bordered on contempt of court, and the Attorney General was ordered by the Supreme Court to defend the judicial service because a justice of the High Court had exercised his powers to cite Mr. Kennedy Yeboah for contempt. I was called upon to defend the justice of the High Court against Mr. Kennedy Yeboah, who we know is a leading member of the MPP. The record will show that I actually mounted a defense of the judge's orders citing Mr. Kennedy Yeboah for contempt. I was not persuaded by the fact that Mr. Kennedy Yeboah is a leading member of the MPP and also a leading Santa Clausian for that record, for the record. I was not persuaded at all. I defended him and the judge of the High Court against Mr. Kennedy Yeboah. And I think that is recorded in the judgment of Justice Yoni Kulendi, dated
No, is it Yoni Kulendi, the Justice of the Supreme Court?
Yes, please. This is Justice Kulendi, Justice of the Supreme Court. In the case of Republic versus High Court, Land Division, Accra, Esparti, Kennedy in Japan. So when I was called upon to indicate whether the conduct of a leading member of the MPP bordered on contempt, I agree that indeed his conduct bordered on contempt. And so the record we show, page 14 of the judgment, said it was argued for and on behalf of the respondent by the learned Deputy Attorney General on 14th October 2020 during his oral submissions before us that the application was fundamentally misconceived. And that's Mr. Kennedy Yeboah's application was fundamentally misconceived. As same was predicated on the false assumption that there are different high courts. Then he goes on. The jurisdiction of the High Court vested in the Justice of the High Court includes the power to commit for contempt, as clearly enshrined in Article 126, Clause 2 of the Constitution. There is therefore no doubt that His Lordship, Justice Amos Wuta Uni, had the power to commit for contempt, even though the words in question were allegedly spoken of a different Justice of the High Court. He cited the dictum of a Kufuor CJ in the case of Republic versus Liberty Press to buttress his point. Mr. Chairman, before you is a judgment in which I have, against the interest of a leading member of the MPP, defended the administration of justice and all. So I can give that assurance to the court, to the committee, that when appointed, I will faithfully administer justice, irrespective of political affiliation or ethnic origin.
Yes.
Honorable Minister-Designate, we all respect you at the bar. To that extent, I've seen the bar president in the chamber to observe proceedings. You are going to be the leader of the bar.
Honorable Member for the Okankwe Central, you know that it is unparliamentary to refer to people in the gallery. So please cut it out.
Very well. I just saw him in the corner, far corner, Mr. Chairman. And you are going to be the leader of the bar. There's been some issues between the bar and the bench, which has led to some lawyers being called before the General Legal Council and what have you. What are some of the things you have in mind to bridge that bar-bench relationship when giving the nod? Thank you.
Mr. Chairman, is that tribal manipulation? Is it tribal manipulation? What would I do? I didn't get the tail end of the question.
That you are going to be the leader of the bar. There's some issues between the bench and the bar that lawyers do complain about. As leader of the bar, what are some of the things you are going to introduce to bridge that conflict somehow between the bench and the bar to foster some sanity within the profession? Thank you.
Mr. Chairman, are you talking about the situation where Justice Superior Court complain about the conduct of certain lawyers which border on contempt? Right, that's right. Mr. Chairman, I am of the view that lawyers ought to abide by the rules of their profession. I am, with all respect, very conservative in my thinking, even though relatively young. And I would want to adhere to the time-honored virtues of the profession. I am also of the view that, yes, judges also ought to act in accordance with the code of their profession, which is to treat lawyers with dignity and respect and to conduct their proceedings fairly and write very sound judgment which can stand the test of time. So I think that, with all respect, harmony can be achieved between the bar and the bench by an adherence by both sides to the dictates of their code. So if a lawyer is to observe the fourfold duty of a lawyer, first, duty to the client, a duty to the court, duty to the profession, a duty to the public. And by ensuring that when cases are pending before court, they do not make unnecessary comments which will prejudice the outcome and which will actually even undermine the foundations of society. I think harmony can be preserved. Secondly, if judges are also exercise their discretion fairly and soundly in accordance with the dictates of justice and the rule of law, the nation will also be better off and will have a sound profession. I don't know if I've answered the value friend.
Thank you very much.
Very well. Yes, Honorable Samuel Pillay.
Most grateful, Mr. Chairman. Mr. Chairman, I would have a few preliminary observations on the CV very quickly. It shouldn't take us more than a minute. I have tried to reconcile this year's CV with what was presented to us 4 years ago, and I hold in my hands the Hansard of 6 April 2017. I noticed a few matters for our records: accuracy and consistency, and educational background. In 2017, you had an entry for a short course at Oxford, June to October 2006, but that doesn't find expression in the current CV under your educational background. Is there a particular reason for that?
Well, indeed, it does find expression. It finds expression under academic fellowships and awards. I recognize that it was a fellowship by the Open Society Initiative and resulted in the pursuit of the program in comparative law, media law and policy at the Center for Social Legal Studies in Oxford in 2006. I felt that because there was a specific provision for fellowship, I should bring it under that part. So that's why this.
Thank you very much. At page 5 of your CV, the second entry, your Broja Jemfi versus Attorney General, constitutional challenge to the Military Defense Cooperation Agreement. Should that be the Ghana-US Defense Cooperation Agreement? You do not specify, just for our records. Which defense cooperation agreement would that be?
Yes, Mr. Chairman, indeed, that's the Ghana-US Defense Agreement.
I also observe that under leadership positions held, you don't give us a specific start date. You may want to consider that later for our records. And then at page 6, the third entry, do we have your permission to clean that up? The chairman, Greater Accra Regional Football Association, disciplinary committee appears repeated.
That's right, yes, Greater Accra Regional Committee. Yeah, this is my committee.
I don't know if you noticed that.
Yes.
April 2008 to February 2009, Chairman, Greater Accra Regional Football Association, disciplinary committee.
Yes, Mr. Chairman, I think the last one should not have been there. It was a repetition. This is my committee, If you consider.
Thank you very much. I want to begin with my substantive questions. A matter I have been probing since these hearings began. Shall I say famous or infamous airport testing antigen test by Frontier Healthcare Services. So far, my expedition has been quite tortuous and eventful. The health minister tells me he has no idea. He has incited the agreement. The foreign minister-designate told us yesterday she was not consulted. You were in the Attorney General's Department. Article 88.1 makes you the principal legal advisor to government. Are you aware of this transaction? Did you prefer any legal advice to this transaction?
Mr. Chairman, I was not a principal legal advisor to the government. I was Deputy Attorney General. And my Lord, Mr. Chairman, the duties of a Deputy Attorney General or a Deputy Minister is to assist the Minister on matters that are assigned. Mr. Chairman, I'm not in the position to tell whether indeed it was referred to the Office of the Attorney General. Even this afternoon, I've indicated that the Japan transaction, even though I've spoken about it extensively, I was not the one who worked on it. I was not, because the Attorney General assigns work as and how is necessary.
A follow-up on that. It appears my tortuous expedition continues. Fortunately, you were wearing two hats. So if I can't get you with legal principal advice, you served on the governing body of the Public Procurement Authority. Did that transaction come to the board's attention?
Mr. Chairman, readily, on the top of my head, because there are hundreds of approvals that are taken by the PPA every week, hundreds of them. So I cannot tell whether this particular one. And most of the time, because I'm Deputy Attorney General, accompanied with court, when they are sitting around 10 a.m., I will be in court. I will not be there.
Mr. Chairman, I will move to my second question, which will be grounded under Article 296 of the Constitution, which, Mr. Chairman, I read. Where in this Constitution or in any other law discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. You assisted the respected Attorney General, the Honorable Gloria Akufu. There are two discretionary matters I want to present to you today to explain to us why you exercise that discretion in that manner. The first one is the Aisha Juan matter, which you filed a nolle prosequi and decided not to pursue that matter. At the time, the President had declared war on Galamsey, which continues to wreak havoc and is really an existential threat. We will not have water in the next few years. Already Ghana Water Company is saying they are processing below 40%.